Hi everyone, this is Akshaya Madanagopal, a law student studying BA LLB Honours 4th year in Tamil Nadu Dr. Ambedkar Law University, Chennai. So today we are here to see a video on overview of simplified arbitral proceedings in India. So in this fast running globalization era, there's a great need for an efficient judicial system, and the traditional judicial system has its very own flaw of not being speedy or not being cost efficient, and has become a dump yard of many unsettled and pending cases. So thus, in order to overcome all this, we need an alternative system of dispute resolution, and this has given rise to a new genre of problem solving, that is ADR, alternative dispute resolution mechanism. So practically this video aims at giving a simplified version of how an arbitration proceedings is conducted and how simple and user friendly the arbitration proceedings are. So first we have to know what ADR is. So ADR refers to any means of dispute resolution outside the courtrooms. So it is an amicable settlement of dispute outside the scope of general courts, and it is in a scientific manner with the involvement of a neutral third party who decides it. So there are many types of ADR, and they are arbitration, conciliation, mediation, and negotiation. And in India, there is a special type of local adalats. So in this presentation, we shall see only about arbitration and how its proceedings shall be conducted. And as most public are not aware of how an arbitration proceedings are conducted, they do not come forward to an amicable and peaceful settlement and generally go to the courts. And as a law student, it is my duty to give you a transparent view of how really the arbitration proceedings are conducted and how easy and simplified the procedures are. So first we go into what is arbitration. Arbitration is the procedure in which disputes are referred by the parties to the arbitral tribunal, that is a deciding authority, which gives a decision, which hears the dispute and gives a decision which is called as award, which is binding upon all the parties. So it is an informal and non-judicial trial which is governed by the Arbitration and Conciliation Act of 1996, and the whole essence of this procedure is that it is a very consensual procedure which is done with the consent or in the agreement of the parties. So according to section 2(1)(a) of the Act, it is given that arbitration is any arbitration whether or not administered by a permanent arbitral institution. So it is an arbitration is a procedure in which the parties go into a settlement outside the court. Now we know what arbitration is, and now we have to know what manner in which the arbitration shall be conducted. That is the steps in which the proceedings are initiated. So the first step is to initiate an arbitral tribunal. That is the officers who decide and hear the dispute. They are the presiding officers over the proceedings, and they shall conduct the proceedings in a very fair manner. According to section 10, it gives that the parties are free to determine the number of arbitrators, that is the persons who give the judgment or the award over the dispute, and this award number of arbitrators shall be not be an even number and shall be an odd number, so as to avoid confusions when taking the majority during the decision. However, the parties can decide the number of arbitrators. In the case of Group Chimique versus Southern Petrochemical Industry Corporation Limited, it was given that the parties only selected 2 arbitrators, that is an even number, which is not permitted. So the court held that a third neutral person shall be appointed, and he shall preside over the proceedings. So first we understand that the arbitration tribunal shall be instituted, and it must be an odd number, not an even number. Now, what is the procedure in which they are appointed? So, according to section 11, the procedures for appointing the arbitrator shall be decided by the parties themselves, and his nationality also shall be decided by the parties themselves. For example, if there are 3 arbitrators, each party shall select one arbitrator, and the third arbitrator shall be jointly appointed and selected by the both parties. So the previous two persons shall appoint a third neutral person, and all this must be done within 30 days in order to give speedy justice. And when the parties fail to do all these procedures, on application, the Chief Justice of the High Court, respective High Court, shall appoint the arbitrators from his own panel of arbitrators. So his decision is final, and if there are two methods, if the parties cannot decide, then the Chief Justice of the High Court shall appoint the arbitrators. And in the case of Ace Pipeline Contracts Private Limited versus Bharat Petroleum Corporation Limited, it was given that the main criteria in appointing an arbitrator is that he must be an impartial person, a neutral person who shall preside over the proceedings. Now the deciding authority is appointed. Next, we have to see what are the rules and procedures in which the arbitration proceedings is governed. According to section 18, it is given that all parties must be treated equally. That is, must be given equal opportunity of hearing and equal opportunity in impartial way of conducting the proceedings. So we understand that all the proceedings are governed by the principles of natural justice. And in the case of Union of India versus Hindustan Development Corporation, it was given that when an arbitration proceeding is conducted in an unfair manner opposed to the principles of natural justice, the award shall be set aside. That is, it is an invalid proceedings. So all the proceedings must be fair and give proper justice. But what really is the procedure of the arbitration proceeding is, it's given under section 19 that the parties itself can decide the procedure in which the proceeding shall be conducted, and if they do not decide or come to an agreement, the arbitral tribunal shall decide any appropriate reasonable manner in which the proceeding shall be conducted, and they also have the power to take evidence, that is decide the admissibility and relevancy of the evidence. So in the case of Modi Industry Limited versus Union of India, it was given that even though the procedures are not fixed, it must be conducted in a very fair and appropriate reasonable manner. So now we know what are the rules and how the arbitration proceedings are conducted. And when you are conducting, you should decide the place in which they are conducted. So according to section 20, the place is fixed by the parties themselves according to their convenience. If they cannot come to an agreement on where the proceedings shall be conducted, it shall be conducted by it shall be decided by the arbitral tribunal itself. So the arbitral tribunal, taking into the consultation of the parties and the convenience of every member, they shall decide the place in which the arbitration proceedings shall be conducted. So next, we shall commence or initiate the proceedings. So to initiate the proceedings, according to section 21, a notice shall be served to both the parties on where and when and how the proceedings shall be conducted. So both the parties shall receive a notice, and the date on which the notice is received by the parties, the proceeding shall be commenced or initiated. Next, we go into the language. There is general stigma around arbitration that the proceeding is conducted in very legal and formal language, and it is not understandable by the general public. However, section 22 says that the arbitration proceedings can be conducted in their own vernacular languages, or any language that is decided or agreed by the parties itself. So it can be English or Hindi, or in their own vernacular languages like Tamil, Telugu, Malayalam, Kannadam. Any language they can conduct their proceedings according to their convenience. So the language is decided, the place is decided, how they are deciding, who is the authority, everything is decided. So what is the actual doings of the proceedings? This when you go into the proceeding, what really happens is, first you must submit a statement of claims and defenses in front of the arbitral tribunal. That is, you must put forth your argument and your points before the arbitral tribunal, and this shall be given in section 23, that a written statement must be submitted before the arbitral tribunal. And when you are the claimant or the petition, when you put the case, you must submit the petition with the facts, the issues and the relief which you need in order to get the judgment. So that is your claimant statement should contain all this, and when you are the defendant or the respondent, you must submit all your defense, and if there is any counter claim, you can counter claim your defense. All this must be submitted within 6 months of the initiation of the program, the proceedings. So everything must be done in a speedy, in a time constrained manner. So it must be done within 6 months, and all the relevant documents and evidence must be attached with this statement. And this statement can be amended during any time of the arbitration proceedings. And in the case of D. Ramachandran versus R.V. Janaki Raman, it was given that the pleadings and the claim must contain full particulars and material facts of the dispute, and it must be in a clear and unambiguous way. It must be very straightforward and clear to put your arguments in front of the tribunal. And next is the hearing stage, that is, you give your statement and the arbitral tribunal shall decide and according to that statement, and the proceedings and the hearings are conducted according to section 24, where the tribunal decides whether to conduct an oral hearing or a written hearing based on the documents which are submitted. So it can be any oral hearing, and if the parties decide that there must be no oral hearing, then no oral hearing must be conducted. But if you are doing an oral hearing, it must be on day-to-day basis without any delay. So if there is any delay or unwanted commotion in the proceedings, extraordinary cost or penalty may be imposed on the parties, and there must be proper notice served that the hearing is conducted here in this time on this date. And when you are conducting the proceedings, the documents and evidence which are submitted before the tribunal must be communicated to each of the parties, so that they can prepare their defenses and claims according to the documents. In the case of Ram Sarup Gupta versus Vishnu in Narayan Inter College, it was given that the hearing is a very important stage of fair trial, and it is very important to put forth your argument and conduct a very fair hearing. And in the case of Lovely Benefit Chit Fund versus Puran Datta, it was given that all the documents and of evidentiary nature and all the evidence must be equally communicated to both the parties for a fair hearing. So all this is over. Your statement is given, all the hearings and the proceedings are done and finished. Then when there is any default by the parties, that is, if the claimant does not submit his claim itself according to section 25, there can be an ex parte judgment, ex parte award or ex parte judgment. That is, if the claimant fails to give his claim itself, the arbitral tribunal shall terminate the whole proceedings itself. However, if the respondent fails to submit his claim or the parties fail to appear before the oral hearing, then the proceedings shall be conducted without any hindrance or without any delay, and an ex parte or a default award shall be given. And when giving the default judgment, a proper pre-warning notice must be given to the default party. That is, in the case of Hemkund Builders versus Punjab University, it was given that the ex parte award is valid only when there is proper pre-warning given to the default party, and even though the warning is given, he fails to acknowledge the proceedings, then a default judgment or the ex parte judgment can be given. Judgment or award shall be given. And other miscellaneous provisions of this proceeding is that according to section 26, any expert on the question of law can be appointed in order to give his report on the subject matter. And according to section 27, the arbitration proceedings shall be take the help of the court in taking the evidence. That is, the parties or the arbitral tribunal shall seek the assistance of court in when taking the evidence. Now the whole of the evidence and all the proceedings, everything is over. It goes to the last stage of the arbitral proceedings, that is the decision stage or the settlement or the award stage. Thus the final award, informally known as the judgment of the whole dispute, is given. So according to section 28, the award is granted by the substantive law of the India, that is, in time being, what are the laws in force in India, using that laws the award is granted. And according to section 29, the award is given by a majority vote, that is, the majority people decide the award. And according to section 30, the award shall not be an award which is selected by the tribunal. It can also be a compromise between the parties, that is, it can be a mutual settlement between the parties, and such award shall be recorded by the arbitral tribunal as an award on agreed terms, and this award also shall be final and binding. And according to section 30, on what forms and contents does this award be given? That is, the award shall be in writing, signed by all the majority of arbitrators, and it shall be recorded in a document format. And this award must be given with sufficient reason based on which the award is given. And when there is no reason may be stated, or if there is any compromise award, then no reason shall be stated. And the date and place in which the award is given shall be stated. After this, the signed copy of the award shall be delivered to each of the parties. So the written document of the final award shall be delivered to the parties. And after the delivery, this award shall be the final and binding upon all the parties. That is, this is the final decision. This is the decision of the whole dispute itself. And in the case of Kapla Textile versus Madhav, it was given that if there is any compromise, and this compromise is written and recorded by the arbitral tribunal, it shall be deemed as an award on agreed terms, and this shall also be legally binding. So when there is a compromise also, that compromise shall be an award when written and signed by the arbitrators. And in the case of Dwarak Das versus India Engineering, it was given that the oral awards are not permissible, and only an award is valid only when it is written and duly signed by the arbitrators. So we come to the last stage, that is, the award is given, the proceedings are come to an end, and all the proceedings shall be stopped. So this is the overall proceedings of the arbitration. So thus I would like to conclude that arbitration is a very simplified and very public friendly process, and the only drawback here is that it lacks publicity and reach towards the public. So thus they are not aware of how simple these proceedings are, and I and this video aims at giving awareness to the public that how simple this arbitration proceedings is. And if you look into the matter, you can understand that all the procedures are agreed and with the consent of the parties only, and overall it is a very consensual procedure in which the arbitration itself is conducted. And to simplify everything, the basic arbitration proceedings has only 4 steps. First is deciding authority or the arbitral tribunal, appointing of them. Then you give your statement, and then the statement is given for hearing and discussed, and all the arguments are put forth. Then you give the award. So it is very easy that you put your statement, they decide and give you an award. That's all. It is very simple and very useful manner, and I hope that this video draws light upon how useful and beneficial arbitration is for the general public, and they shall use this for speedy and cost efficient manner of dispute resolution. Thank you.